Well, my learned brothers and sisters, this is Advocate P. Devamarari talking to you from Ahmedabad city, Gujarat state, India, that is Bharat. Hope you enjoy Holi and Dhurati. They are the auspicious festivals in our country. And today I've selected a very interesting topic from criminal law. And all of us should know about this. That is why I've selected this. The concept of cruelty and its effect from criminal law. Applicable is Indian Penal Code Section 498A. And new law is Bharatiya Nyaya Sanhita 2024 Section 85. Presumption as to ability of suicide by a married woman. For there are two sections there, Indian Evidence Act 113A and Bharatiya Saksha Adhiniyam Section 117 and 118. Now let us see, understand it, Section 498A, that is BNS Section 85. Now Bharatiya Nyaya Sanhita, I will describe it as BNS. It deals with husband or relative of husband of a woman subjecting her to cruelty. I'll read out. Whoever being the husband or the relative of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Now, what are the ingredients of the offense? In short, there are 3 ingredients of the offense. Number 1, the woman must be married. Second, she must be subjected to cruelty or harassment. And third, such cruelty or harassment must have been shown either by husband of a woman or by the relative of a husband. IP Section 498A, BNS Section 85, does not specifically speak of dowry demand. It speaks of unlawful demand for property and valuable articles. For constituting offense under Section 498A, it is not necessary that infliction of cruelty should be one based on dowry demand only. And type of cruelty is cruelty for the purpose of any type of cruelty is cruelty for the purpose of attracting ingredients of Section 498A IPC. Never be under the wrong impression that you have not demanded dowry, so there is no cruelty. No, any type of cruelty is the ingredient of this offense. Citation 2008 and bracket 2, Gujarat LR 1781. Another one is 2000 Criminal Law General 4793, Calcutta. What is the meaning of cruelty? Basic ingredients of Section 498A are cruelty and harassment. The elements of cruelty so far as Clause 1, Clause A is concerned have been classified. A1, any willful conduct which is of such a nature as is likely to drive the woman to commit suicide. Or 2, any willful conduct which is likely to cause grave injury to the woman. Or 3rd, any willful act which is likely to cause danger to life, limb or health, whether physical or mental, of a woman. Citation, year 2010, SC 3708. Another one is year 2013, SC 1567. In order to constitute cruelty, it is not enough that conduct of accused is willful and is offensively unjust to woman. This is not sufficient. But It is further necessary that degree or intensity of such conduct on part of accused is such as likely to drive woman to commit suicide, or such conduct is likely to cause grave injury or danger to her life or limb or to her mental and physical health. Only those acts committed willfully and which are in the nature of degrading treatment, which qualify to be treated as cruelty in law. It is a conduct designed to produce definite result. Here it comes intention, means you want to produce a definite result or relation to physical or mental condition of a woman. It is cruelty. In the event of these being a state of conduct by the husband to the wife or by any relative of the husband which can be attributed to be painful or distressing, the same would be cruelty within the meaning of section 498A of IPC. Citation AR 2001 SC 2124. What is required for making out an offense punishable under section 498A is that the injury to the mind or body ought to be of a grave nature, and any simple injury would not be sufficient. For simple injury, there cannot be IPC section 498A. Cruelty means unprovoked conduct towards one's spouse which causes embarrassment, humiliation, and anguish so as to render spouse's life miserable and unendurable. Now see, there is reference of Hindu Marriage Act. Hindu Marriage Act 25 of 1951, words cruelty not only includes physical harm but also mental distress. Though HMT Act means Hindu Marriage Act, recognizes cruelty as grounds for dissolution of marriage, but it has not given any precise definition of cruelty. Acts or behavior causing danger to life, limb, or mental health of spouse, leading to reasonable apprehension of danger, can be considered as cruelty. Citation year 2024, Calcutta 130. The expression cruelty postulates such treatment as to cause reasonable apprehension in the mind of the wife that are living with the husband will be harmful and injurious to her life. 1995, Sierra LJ 340, Bombay. To precipitate cruelty as defined under section 498A, continued intimidating conduct and behavior is essential. It is quite comprehensible that in a given fact situation demands harassment and intimidation may be caused by phone or letters or other modes of communication. Whether a given piece of conduct can be reckoned as willful or not will always remain a question of fact and will have to be decided by the court, taking into account all the inputs, including the social circumstances of the parties. To decide the question of cruelty, this is very important. What are the factors to be kept in mind for determining the cruelty? And a court will decide, but what should be the defense of the lawyer? To decide the question of cruelty, the relevant facts are the matrimonial relationship between husband and wife, their cultural and temperamental status in life, state of health, their interactions in the daily life, which dominate the aspect of cruelty. Cruelty, proof. This is committing suicide due to constant nagging by in-laws for being issueless. But no physical cruelty alleged. Fact that nagging continue for more than 10 years cannot be said to be persistent mental cruelty. Undoubtedly, to a large extent, the concept of cruelty will be subjective, but no claim of cruelty can be made without an objective test. Objective test has to be made. As reactions of different persons vary, the extent of cruelty treatment needs to be objectively assessed in order to see whether a reasonable or average person will be likely to be driven to commit suicide or cause grave injury to her on account of such treatment. In order to prove cruelty, there has to be series of events. Clause A of explanation provides that beating would not come within the meaning of cruelty under section 498A. But if such beating is likely to cause death or grave injury to the body, then only section 498 would attract. Daily petty domestic quarrels between wife and husband will not attract the term cruelty. Where there is conviction of accused. Well, my friends, this is the end of the video. Hope you have got some very nice information. If you like it, please subscribe it, share it, and see you in the next video. Shri Krishna Saranam Mama. Thank you, thank you, thank you.